Okay, yeah. Karin.
Yeah, thank you. So I too also only have like a very general ideas, a few ideas. I don't think I'll have time to flash them all out, but before I do that, I wanted to start just with a general statement. It's like kind of that thing that is obvious that we shouldn't talk about because we already know it, that we are here by ourselves, that but we should talk about because it's here. And that is that when we come to think about Gaza as paradigm, which we have to remember who we are when we come to think about it and who is not here. And that from the place where we are, which is us, Israelis or visitors or scholars with privilege and with great responsibility, that we come to this topic. And in that, I think that we really need to listen to Gaza's lawyers, Gaza's advocates, and other Palestinian activists speak about the status of Gaza in international law, because this is what I thought we're talking about, like where we're talking about this in terms of international law. And I think we tend to assume that we know what they're saying, and we assume that we know what they should be saying, but we sometimes ignore their words and their language and the living discursive practice, which they do, which is to make claims in international law. And so we should listen to those claims. So what I wanted to suggest is to try to take this seriously, to pay attention to the voices, to those voices. And I'm going to be trying very, very initially here to do that. And I'm going to do it in relation to three paradigmatic turns or shifts that I think are you can find in international law more generally and in public law more generally, and that have important connection, I think, to how to think about Gaza in international law today. So the first one I'm going to talk about, and maybe I'm only going to talk about one because I don't know, is this shift to empire in historiography of international law. And this shift was proposed and developed by 12 scholars. And this is a general turn in historiography of international law, but it also reverberates or echoes in this focus on coloniality and decoloniality in other disciplines and in popular imagination, with the idea that subaltern populations, political communities, victims of colonial oppression, indigenous peoples, and the descendants of slavery share a history of oppression and of resistance to oppression and a common political project of decolonization. So this is a trend, and it's not a new trend, but it has recently been invigorated by such movements as the Black Lives Matter, global environmental struggles, local movements of different kind, and so on. And so I claim that Palestinian scholars and lawyers and activists are, in a way, native to this language. And when they speak about Gaza in international law, they speak in the terms of colonial histories of international law. And they are, in this respect, norm makers of international law. Because for them, this is not because they are norm making because of the way they act and the way they speak, and where they act and where they speak, but more than that, for them, it's not a theoretical or intellectual framework. It is a basic reality of experience, and they understand it from within. So when they describe Gaza, and I started to look at a lot of reports and interviews and podcasts and articles written by Palestinian scholars, and some Gazans, some out of Gaza, some from the diaspora, and there's differences there too. But the histories often, they tell often the history that starts in early 20th century Ottoman rule, then the Western colonial intervention, and a century-long, they describe as a century-long colonial war that was and still is waged against Palestinians. This is the language they use. And that war did and is still displacing, dispossessing, and fragmenting Palestinian civilizations of Palestinian society. And at the same time, they talk about these century-old traditions of resistance to colonization. And some of the terms they use to characterize what Gaza is in international law are in this respect very telling. They speak about Bantustan. They use ultimate segregation to describe what's going on in terms of what the blockade is. Medieval blockade, indefinite warehousing of unwanted populations, a holding place for 2 million people who are just able to survive but not able to thrive, apartheid, open air prison, closure. These are the terms that are being used in these literatures. And this language, I think, is still too foreign to us lawyers, Western lawyers, who argue about the status of Gaza in international law. And we tell ourselves a very different backstory and use very different categories to argue about the correct status of Gaza. I'm not saying that we should use the same categories, but we should be aware of this category. So what do we speak? We speak about occupation, about disengagement, about governance, effective control or lack of effective control. We talk about physical presence or lack of physical presence. We ask about sovereign rights and obligations under a functionalist framework, a post-belligerency framework, other constructed frameworks within international law. And the history that is often told in these debates also sometimes starts in the beginning of the 20th century, but it's a very different, much more, orderly history of the development of the nation state, sovereignty, and development, and the complexities that confront it, from Ottoman sovereignty to British mandate to belligerent occupation by Egypt and belligerent occupation by Israel. We focus in this kind of history that is being told in these debates on the peace treaties from Camp David to Oslo, and aim to end the conflict, the disengagement plan, transfer of power to Hamas, and then, transfer of power, and then Hamas violence. And in this history, Israel is not described as a colonial power, of course, but as a law-abiding, more and less law-abiding state, an equal sovereign, a peace-loving treaty-making entity, functioning under a complex situation. And the Palestinians are basically vanished. They are non-existent beyond the roles that Israel defines for them, either as administrators of a Palestinian autonomy of some kind, or as terrorists. And I think this also is really echoed very strongly, or the way what I see is that it's echoed strongly in the sources and the methodologies that are being used in these debates about the status of Gaza. And if you look at them, they're overflowing with references to Western sources. So British, US, German, Norwegian, Danish, New Zealand, Australian military handbooks and guides, and European, American, Australian judges, courts, scholars. Not in most of them, you would find not one reference to a Palestinian scholar that informs the analysis. In best case scenario, it would be a Palestinian who would just be used to describe the situation, the reality of it, so more journalistically, but not to the analysis. And usually not even one non-European source, not even one woman in many of those articles that try to explain and reconstruct the status of Gaza today. Not one indigenous voice, not even for the sake of presentability, not any of that. The colonial powers utterly and totally dominate the source material these sources are called to support Israeli impunity, and proves the point that Palestinian scholars are making, that this type of discourse is deeply embedded in a colonial tradition. And we know as scholars that it's not the first time that an expansionist power carves out spaces for control without responsibility or with limited responsibility, using colonial law to justify and legitimate its use of force or its expansion. In the 19th century, differentiated layered classes of sovereign states were constituted, some fully sovereigns, others partly sovereign, some part of the family of nations, some outside of the family of nations, some entitled to dominations, others have minimal legal competence. A sliding scale existent already in international law in the 19th century of layers of sovereignty, and it emerged stretching from great powers to colonies, with suzerain, protected states and protectorates positioned in between. And we also know that recently in the war on terror, we saw this phenomenon emerge again as the US carved a non-sovereign space in Guantanamo Bay to perform extreme violence with impunity. So this ability to create space within a colonial context to do things without the need to directly administer a space. And this is the history that I think is the big elephant in the room in the debates about the status of Gaza today, whether the authors wish to resolve Israel of its responsibility, or in most cases actually to construct responsibility. But this is the history that's missing. And these are the sources that are missing. And this is what becomes very explicitly clear in the scholarship of Palestinian and the discourse of activists when they are called to speak about Gaza in international law. So my point here is that we as scholars must pay attention to these gaps and find ways to overcome them. We must learn to listen to the language of the Palestinian claim making in international law. So this is basically the first turn that I think is important to pay attention to as we speak about Gaza. The second one, and I don't know if I have much time to go on into them, is if this one is a methodological claim, maybe basically claim that we should pay attention in the questions we ask to those voices, to these sources, to these histories, then the other one is more doctrinal, and it's the shift in the theory of transgression in international law, or the theory behind international criminal law. You can find it a lot in genocide studies today, that also have gone through this imperial or colonial turn, criticizing, when scholars in these disciplines, criticizing the current understanding of transgressions as modeled on genocide as the crime of crimes, modeled on the Holocaust, in order to see, what they suggest is that we see, name, map, study atrocities, and we have to give them names and terms, that were and are perpetrated in the context of colonial expansion, settler colonialism, and especially colonial wars. And there are different ways in which scholars try to shift this focus to transgression, of transgression speak, of the language of transgression, shift it from looking at the boardrooms to, so one of the ways is to shift from looking at the places where decisions are being made to the points of view of and experiences of other participants in these wars, in the wars that happen in the colonial context. But another interesting way that recently was suggested by Derek Moses in his book, The Problem of Genocide, Permanent Security in the Language of Transgression, is, so if the first way was again more, methodological, we look at those people, we look at those voices. What Moses identifies is a problem in the theory and practice of international criminal law and in genocide thinking about genocide generally, that he terms the problem of genocide. And he says, if for 500 years of your Western expansion, we had a lot of debate about different types of international transgressions, about, the limits of what you may do when you expand, and what is considered legitimate and what's considered illegitimate. In the 20th century, or was considered beyond the pale. In the 20th century, especially following World War II, it became fixated, or this discourse of transgression became fixated on a particular hierarchy of international crimes modeled around the experience of the Holocaust. And Moses suggests that what really, first he suggests that this is, not very helpful to make all of us really focus on the very, very extreme and very, very ethnically focused crime of genocide. And instead he says that in many cases of extreme violence, and extreme in the sense of how many people die, but also in the sense of for how long people die, and what kind of experience people have on the ground, is in the center of that is the imperative that drive many states towards what he calls permanent security. It's this desire for permanence. So the desire that never again will we be vulnerable to this minority or to that insurgency to attack us. Mm-hmm. Mm-hmm. And that's the problem. And that it leads to a logic of preemption by the security apparatus, anticipating future threats to care for that permanent security. And that this impulse, the logic of permanence, tends to escalate to finding something that would be a final solution of security. And there are different such solutions to the problem of permanent insecurity that colonial and expansionist projects encounter. They're real projects. They're real problems of security that they do encounter, but they move towards the need to find a final solution that will permanently end that situation. And those different ways of making final peace or making final security happen are very different from one another. So, you could see the atomic bomb as one final solution, right? There's also mass incarceration, mass expulsions, and also a permanent blockade or siege of some kind. And so I don't think I'm going to go more into that because there's a lot, but one thing that's, I think, valuable about this kind of thinking is it doesn't, it makes it possible for us to think about, well, at least the way Derek Moses describes it, about this as a continuation, or there are different kinds, different types. There are some projects that are liberal, permanent security projects, like a permanent war on terror, but there are also many illiberal permanent security projects, like Russia's war on Ukraine, or what the Chinese are doing in against the Uyghurs. And so there are different ways to look at it, but what the important thing is to move our discourse and our sensibilities from the context of 20th century transgression of genocide, this particular type, to a broader incidents and broader contexts and context of coloniality. So that's the second shift, and the third shift that I want to end with is this idea to shift in thinking about international from a discipline of crisis to a discipline of everyday life. And this is following the very powerful suggestion of Hillary Charlesworth quite a few years ago already, but I think it has continuing life in thinking about international theoretically. And I think to de-exceptionalize the Palestinian case, to de-exceptionalize Gaza, not to allow us to go back to an idea, so this is a sui generis case, this is to say this is not so exceptional. It's within a history, within a tradition. We have to think about the history and the tradition to understand what this is. And we cannot, and to also not, think about Gaza as separate from Palestine. That's one thing. And also not so separate from other struggles like the Black Lives Matter struggle, from indigenous people's struggles. I think that could, and really connected to the everyday life of people in Gaza, their real problems. And so that's generally the kind of ideas I had.
I think this is brilliant. I really, really do think that Dirk Moses's model is so illuminating on the situation of Gaza, precisely because of the way that what seems to be an enormous atrocity is couched in legitimacy and legality all the way down. And I think it's really, I think Dirk Moses also wrote about Gaza specifically in one of his papers, but I think it really is an extremely useful lens to look at. And essentially, Dirk Moses is participating in something that we might call a competition over what is the worst crime. And if I understand correctly, his suggestion is that genocide is not the worst of crimes, or not necessarily the worst of crimes anyways. Genocide is distracting us when it focuses on the ethnic unity of the victim and on the special intent that is required. And all these cases of colonial violence don't have necessarily that. Genocide also delivers the result that that whenever someone is acting politically, they become more vulnerable to legitimate violence, politically or indeed in armed resistance. But the ultimate victim is a victim that is only killed as a victim, regardless of what she or he has done in their life. And I think it's extremely powerful to think of Gaza that way, precisely because of this aspect of permanence that you address. But I also have some questions to Moses that I'm kind of...
ask me.
Curious to see.
I'll channel him right here.
No, I mean, how did they, in terms of how they pertain to the project?
Yeah.
So one thing is that I don't think international law necessarily has that hierarchy as a doctrinal matter. Indeed, there is a case from the ICTY where they say there is no essential hierarchy, and each case needs to be considered on its own terms in terms of violations, abuse, cogence, etc. So, if that's the case, then the argument doesn't really work in some level. But also, if we assume that, then we can think, what about the aspect of intent? And doesn't it really make things worse if the intent is to kill someone for who they are, or to harm someone for who they are? And so if you take, for example, an international crime with X victims for X amount of time, and the only differentiating aspect is the intent, isn't it worse if the intent is genocidal? And with the context of Gaza, do you think that you need to at all engage questions of intent that have to do with the closure? What are its aims? Are its aims security aims or economic regulation aims, or indeed just racial extermination aims? So that's I guess one question.
Yeah, so maybe
I have another one. Okay, go ahead. Yeah.
No, just to say, I don't think he's participating in the competition, and I think he would say that there's no one crime of crimes, and the whole point is that there are many types of transgressions, and we should look at them, and we should not see one as beyond the others. And I think that he would say, in terms of the hierarchy in international law, that of course there are claims about it. First of all, he will say that maybe that there's a trend towards the hierarchy, but also that he would recommend to think about the convention that would deal with permanent security as a possible additional source or tool that we have to see that we will one day have in international. So not to replace one for another. But in terms of what's worse, I mean, I think that many times in the context, in the colonial context too, the race is really important. It's not like it's not there, right? It's obviously race is all over the place in the colonial history of transgression, but that's the whole point. So it's not only about race. It's about race is a part of the construction of political construction, and it's just the race and ethnicity is what exists there. So you should be paying attention to that too, but not as a mark of what's beyond the pale, something like that.
Okay, and with the context of Gaza, do you think that you need to engage with intent at all?
I don't know. No, I mean the intent. I think the logic of permanent security is aiming to capture an intent. Mm-hmm. But I don't know how to. I'm not at the level of.
It's really, really interesting. And one of the things I'm moving back to the way Palestinians talk, because I think it's related. So one of the things you hear is your fear cannot justify what you're doing to me. And so in that sense, permanent security is having a fear that is allowing you to use more and more possibilities to quash that fear on while harming someone else in the process. And so I think so it is, instead of intent, it's just the opposite. Your intention for self-protection that is out of proportion, which is kind of strange because, there's just this whole thing about proportionality that's being discussed now recently on Twitter because of Zvika Fogel. So he's a recent MK in Jewish Power.
He's a recent what?
He's a recent member of Knesset elected through Jewish Power. Used to be something high up in the army, and he mentioned and he said something like, if one Jewish mother cries, then 1,000 Palestinian mothers will cry, and then it brought this whole issue.
And he also said, I'm supporting eliminating the category of proportionality, just eliminating that.
Right. So this whole thing, so that kind of, so there you have intent that doesn't have to be directed to a person. It would be enough that he would say one Jewish mother would cry and whoever would, 1,000 ex-mothers would cry, and it would be the same thing if we're going to the permanent security.
With regard to his statement, I think it's genocidal. So we don't need even the permanent security so much.
No, it's for sure genocidal. And what I'm saying is, if we use that to think about what causes. Okay, yeah. So what causes that statement? That statement is fear, right? fear that then turns into.
That's the logic behind it. And I think that Moses, what he's doing, he's not saying genocide is going to disappear because we're in a, we don't have that anymore. We're saying that genocide, there's something genocidal in this impulse to security, to permanent security, not to security.
No, I think he wants to separate himself from genocide. I think he wants to separate himself, to say this is something separate, but also very, very bad.
Yeah, no, he wants to make separations. He wants to do these separations because, you see, he thinks that this category, just blinds us to other things.
Yes.
And that the ability to name certain things as not genocide. But in terms of the analysis of the situation, he can see how the idea of permanent security can lead to genocide too. So
Yes.
I'm going to have to go really soon, which is unfortunate because I'm having a good time. Such as it is. But I don't know. I haven't read Moses, though obviously I should. But I want to raise something which I think is in all your 3 points, which is the question of comparison, right? So there are different things being compared. And I think I'm originally from comparative literature, and I think we need to think closely about how and what we're comparing. And I think that one of the things about the hierarchy of atrocities is not only that the hierarchy, so we're saying we shouldn't have a hierarchy because then it just creates a race to whatever and devalues other things, but seeing them sort of each in their own turn. But so it's not only the problem of a hierarchy, but it's also the problem of seeing one atrocity in terms of another, right? In other words, and that's just human, how our brains work, right? We need categories, we need to see categories in terms of another, but we also need to be very aware of how we're doing that and how we're seeing one thing in terms of another. And one of the things that's like my pet thing that I keep coming back to is trying to think of comparison in terms of contiguity. In literature, we say metonymy instead of metaphor, right? So instead of saying this is like this, that is like this, or unlike, right? One, setting them next to the other and comparing them, seeing those things that we are comparing as part of the same field. Right? So if the field is colonialism or is the field, right? This is not to say, so we're not seeing them in terms of each other and comparing how they are better or worse or different or same, but rather saying how do they draw on similar or not even similar, how do they draw on these discourses? How do they have a shared history? And to think of comparison in those terms, right, to create new fields or new objects of study by placing.
I actually think Moses took the idea of permanent security from a very German Nazi place, which is the testimony by a Nazi field marshal or whatever in the East that explain the logic of why do they need to kill all that population of Jews, like the kids and in Ukraine. Right. Say explaining it from the point of view of security, saying it's what we're doing to the Jews. Those kids are going to grow up and become, they will all want to kill Germans, right? So we need to kill them too. It's a logic of security that was embedded. So he's saying Nazi, what we think of Nazi, of the Nazi empire was an empire in a way, in the way it was thinking security was too. It was not only about killing Jews because they're so, ugly. It was about creating a security, seeing Jews as foreigners who are a security problem for the Nazi regime, which is supposed to be permanent for 1,000 years. So, that's so he's not like, I think his shift is more subtle. Like this shift is not succinct.
No, again, I should read this, but but I do think that, like, what your first point about the different discourses is really interesting, right? The choice of the specific, right? When they say medieval blockade, or, right, the choice of discourse brings in, so rather than saying, I am here and that is there and this is the way they are similar, it's saying, I am bringing that medieval context, or bringing that into the same field here in Gaza, and there's a contiguity here that I have to think about together, right? So comparison can separate.
So one thing is like an interesting point, which I was thinking. Sorry, there's a question. Because I just wanna connect it to Yael's thinking about Yael's project, like this idea of where do we take the terms from? Like I was describing, these are the terms used by this group of scholars and lawyers and advocates. These are the terms used by the Western discussions about the status of Gaza. And it seemed, wow, there's a huge gap. You just see it there. But where do you take the other terms? Like, where do you start to come up? Where do you find the terms that could make it into one field? And I don't know if it's a...
No, I mean, I just, one of the things I've been thinking, sorry.
No, it's okay. You can answer and like, yeah,
Okay.
I
just, one of the things that I find really hard, and it's also hard to talk about, is how colonialism and its categories are very, very hard, because the opposite of colonialism is liberation. So what do you do, or independence? What do you do in these interms? What are these possibilities now there? It's really, really interesting when you think like kind of Gandhi asking, is India, Gandhi, 1910, goes...
Not my Gandhi, the other one.
Right. Asking to be a citizen of the empire. So like the pre-liberation thing is to take part in the empire, and liberation is only after that's an impossibility. But the point is that in this struggle, you do not have any kind of in-between status.
No. So I think that the language of claim making in international law that Palestinian scholars and advocates are making, in a way, is an empire making project too. I mean, it's a big claim, but I want to
Totally
make it still. Sorry.
Yeah. No, language imports a thing. I would think
it's not only language; it's acting. It's norm creating.
Right.
It's creating new limits of what is okay, what's not okay. Creating new traditions of what's the history of where we're coming from, where we're going to, and it's international to some extent, and so that's one way to look at it. It's not that the project of liberation that is anti-colonial is only it's only domestic or national, right? It's also an internationalist project, right? And imperialist in some ways. So.
Can you please elaborate more in regard of the framework approaches for international law? If we kind of adapt this more in the Western world, we'll have more for Palestinian scholars' voices. Do you think that angle will be kind of strengthen the future?
I think that this angle is already there.
Yeah.
But it's sometimes less, sometimes more marginal. But because 12 scholars, see that, but in terms of the reality of the world, not completely sure that third world is completely marginal, right? So there are different actors that could bring certain ideas forward in certain institutional contexts international. So but I'm not thinking I'm answering your question, which is exactly. What is exactly
like this angle? This is the problem with, like, I'm part of this thriller, but the problem that whenever we sit together, it's the same problem with Palestinian, where we have like Palestinian scholars discussing only Palestine, the separation. We talk with each other, we can deliberate new ideas, like
right.
Discuss in depth,
right.
But it's just among each other, denying of the other voices rather than just a challenge.
I think there's a lot of work to
there is
do
kind of this
for
questioning
us.
Like de facto, do we do really something supportive, like the implementation of how we could kind of provide some resolutions to the people of Gaza if we just keep criticizing the international rather than trying to use should we because community demolish the whole international tools or rather than for those people living the reality and again us as a privileged academic thinking theoretical aspects of things. And I think one of the main problems as well is that we keep discussing the topic criticizing the international law from our own angle and perspective, but the fact we don't really provide much more than theoretical, more articles critiquing the
So I think those Palestinian scholars and activists are actually creating realities in institutions like the ICC. They go there, they do things, and they're very and it's not that I'm trying to say this is the way to go. I'm just saying that the debates that don't see that happening are really problematic. They're problematic in terms of getting a clear picture of what's going on, and they're problematic normatively because they're missing a lot of really important voices. So, but in terms of tools, this is exactly what is needed. We need more tools to do things, and the tools are, some of the tools that are already created are problematic and should be, criticized and looked at, and
But I'm finding this exchange possibly the most interesting, really. So, what kind of tools? What are you talking about when you say when we stand and critique and want to dismantle? Should we be using tools to do for the people of Gaza directly? And then Karin says, no, yes, there are things that are happening. There is an impact of the theoretical and conceptual, but it's lacking tools. So what are those tools?
I just have one example in regard of the tools, the limitation of the tools, where I find myself as lawyer more powerful than as academic. Let's say when we are dealing with rather than because we're doing something de facto on the ground to support kind of the people strongly in a way, although I know the tools, the limited tools in practice, but still I find more stronger voice sometimes when I kind of find my head more tight why I'm trying to legitimize my non-bias very academic non-activist work, because it should be founded based on the theory and the tools that are existing, despite the idea that I will use the critical ideas.
It's a good question to ask Ralph, because he wrote about that exactly, using the tools.
But one problem I'm finding with Ralph as kind of he's to lecture Palestinian how they should do that, and this is
so maybe it's not a good question
when we have.
But I think the tools are the tools that you use as a lawyer are not completely separate from the tools you use as a scholar.
I know, but
not at all. And
not
it's
at all? Okay.
I mean, not at all in the sense that there's no value to scholarship if it's not about what you can do, right? What is out there? I don't. Well, maybe it's a very philosophical, too philosophical answer, but I mean,
I think Hadeel, you're speaking about the position. So, in order to establish your legitimacy as an academic, you have to refrain from that exact application that you would use as a lawyer when you're taking a side.
Exactly.
Right. Yeah. So it's but this is, it's definitely a question that we have as lawyers in general. Yeah. I mean, it's a wider question that I think becomes so important for Palestinians because of the situation, because the only tools are international law. You don't have anything else. You just have that. And so, but I think that's something that is worth talking about and worth yeah, I think so. I just
want to finish by saying, to reply to by saying that what I see, and I said that I think that Palestinian scholars and advocates, meaning lawyers too, are speaking from within the law. So they are insiders. They're inside actors.
Yeah, but the designation of the 6 NGOs that only working in international law and in law and using the law tools, then silenced, using the military system.
They're silenced.
Yeah, exactly. So how we could just overcome this obstacle, for instance.
So if it's a political obstacle, we have so many.
Yeah, indeed.
We're not going to overcome. But if it's in terms of thinking, we can. I mean, the political obstacle is going to be there.
Okay.
That's exactly.
Okay. So should we go? Okay. There's more to talk about, but maybe.
Yeah.
Okay. Thank you so much.